May it please the court. My name is Alec Russell. I'm here with my partner in this case, Mr. Paul Parrish, and we represent the appellant Lee Tae Kim. We're asking the court to reverse a summary final judgment ruling that Mr. Kim's nursery stock trees transformed from his personal property into his friend's real property when they were planted on the ground, despite their contrary intent.
It would have been real helpful if Mr. Kim had a lawyer, right?
It would have been helpful. It could have been helpful, Your Honor.
Yeah, I mean, unfortunately, he's stuck with his own legal work, which is troublesome.
In a sense, Your Honor. However, the law under Florida Supreme Court precedent holds that those trees did not transform from personality into realty when planted, because that was contrary to the intention of both parties. The trial court applied the ancient rule, quid planetar solo.
Yeah.
So
I think we're all up to speed on the ancient rule, and we're all up to speed on the exceptions. And you've only got 15 minutes. You kind of want to make your points. I want to help you kind of get right to
sure,
it.
Your Honor.
So the difficulty is we have to look at this 2011 agreement, and we have to make some sort of sense out of it, correct? I mean, that's our focus, isn't it?
I don't think so, Your Honor. I don't
So
think
the
so.
agreement doesn't matter, huh?
I think, I'm not saying it doesn't matter. Well, actually, it does not matter. What matters is what happened at the moment the trees were planted in the ground. Did they remain personal property because of the fact that the parties intended to later transplant them and sell them to customers? Or did they transform into real property against the intention of both parties? Later, what the letter agreement was about was Mr. Kim and Mr. Lizey had established two tree farms, one on 19th Avenue and one on Gulf City Road.
Well, it appears to be a dissolution of a partnership of some type, is what that was.
It was of sorts. It was really more of a modification. It was a change of the partnership wherein Mr. Kim told Mr. Lizey, I'm going to give you my 6,000 trees on the 19th Avenue property. And Mr. Lizey in exchange said, you can grow your 4,000 trees on the Gulf City Road property indefinitely until you're ready to sell them. And they memorialized that with the letter agreement that Mr. Kim wrote saying he would only have the trees on Gulf City Road. But
all these statements by Livesey, of course, he's deceased now, right?
He is, Your Honor.
So these statements aren't even admissible in evidence, are they?
The statements.
Because you're talking about things here as though there are facts, known facts, and they're not even admissible.
Mr. Lizey's actual statements would not be admissible in evidence. However, Mr. Kim's testimony concerning the intent of the parties, concerning his intent.
Well, I was going to say, you can't talk about the intent of Livesey, can he?
He can talk about their agreement. He can talk about their oral agreement that the trees would remain.
Well, he can
personal.
talk about, well, how can he do this? That's all hearsay by a person that's deceased. So he can talk about his view of what an oral agreement was, but he can't talk about what Livesey said or what Livesey, his expression of his intention. You can't talk about any of those things.
An oral agreement is a verbal act that is admissible in evidence, even though the words of parties may be hearsay. When two parties enter into an oral agreement, that's always admissible in court, just like a written contract is always admissible in evidence because it has independent legal significance. It's not simply hearsay.
Well, here's my concern with the case, counsel, is this. You kind of use this agreement as a sword and a shield. You sit here and tell me it's an agreement that Mr. Kim owns these trees in perpetuity. And then you turn around and say, well, that's just simply memorializes something. And now you're saying it's a modification of the partnership agreement, but you have alleged the partnership is dissolved. How do you modify a partnership that's dissolved? We don't have a partnership agreement to see if it can be modified orally. It's a moving target in this case, because if you look at the plain language of the agreement, the intent of the parties doesn't come in until it's unambiguous. The plain language of this agreement is, these are two old friends which I respect. We respect this situation. Two old friends that had a tree business. They no longer have a tree business. And the owner of the property says, you own those trees on that property, but I own it. It appears that you own those trees until my death. It doesn't say anything about you can continue the nursery business. You can continue to plant more trees. It says you own those trees. Not that you're gonna plant trees, not that you're gonna cultivate them, because with respect to Mr. Kim's responsibility of the property, it doesn't even talk about taking care of the trees, it just says remove unwanted debris, that's trash. So it doesn't even contemplate, even in its own express language, the continuation of a business. Help me.
First and foremost, Your Honor, we do not base our claim of ownership of the trees, Mr. Kim's ownership of the trees, on that written letter agreement. That written letter agreement was something that Mr. Kim prepared and the parties signed just to clarify that Mr. Lizey was obtaining the 6,000 trees on 19th Avenue. Mr. Kim.
But is it inconsistent with what you're saying? I mean, aren't you saying the same thing, that the trees were Mr. Kim's? I mean, that's what the agreement says too. I don't know that that's really inconsistent.
The trees were Mr. Kim's. Mr. Kim had grown those trees about a decade earlier, harvested them from seeds from his mature palms, nurtured them for years in his nursery before planting them for this joint venture.
And so, and perhaps I've missed something in the record. What happened between the time of the agreement and when the property was transferred by Mr. Lisi into his trust? Were there any efforts by Mr. Kim at that point in time to, just say that those trees are still mine, or secure them in any sort of way?
No, Your Honor, as is specified in the affidavit supporting or in defense of the motions for summary judgment, when Mr. Lizey transferred the land into his trust for estate planning purposes, knowing he was ill, they agreed that the trees continued to be Mr. Kim's and they were going to continue the agreement now with Mr. Lizey as trustee rather than Mr. Lizey individually. And if I may.
But the deed described the real estate, and there was no contemporaneous writing that made it clear that the real estate didn't include the tree, right?
Nor did there need to be, Your Honor. If you look at the Jenkins versus Likes case, which the appellees rely on heavily, even in that case, the Supreme Court of Florida looked at jury instructions and the propriety of those instructions. And the first instruction instructed the jury that a deed of conveyance conveys with it the real estate and everything on the real estate at the time of the conveyance. The Supreme Court of Florida said that is clearly wrong. It says a deed conveying real estate conveys only the real estate and that which is legally affixed to it, but it does not convey personal property at the time upon the real property.
Wasn't that case involving an irrigation system?
No, Your Honor, that's Gracie versus Gracie.
Okay, so then what was the appurtenance in that case? I forgot.
In Jenkins, it was timber. It was a timber case. And in a timber case, the timber in the vast majority of cases is naturally occurring. There's no indication in Jenkins that those trees were planted. So one assumes they were naturally occurring as usual. And the court said that timber can be sold by parole, okay? But it remains realty until you cut it. That's timber. And in a case of fruit-bearing trees or nut trees, pecan tree, an orange tree, an apple tree, what have you, the tree at all times remains remains real property once it's on a citrus farm, because the citrus farmer plants that tree intending it to remain there year after year, producing oranges or apples or pecans. So the tree itself maintains its its characterization as real property, whereas the fruit of the tree, the annual harvest of the tree, becomes personal property when harvested. However, if you look at the case of Story versus Christian, for example, Mr. Story leased Mr. Christian's land, and he leased it for the purpose of growing orange tree, or I'm sorry.
Was there
orange and walnut
lease in the
trees.
record?
I'm sorry, Your
Was
Honor.
there an executed lease in the record in the case?
I don't recall.
Do you have one here?
We do not,
You
Your Honor.
argued before the trial court, I read the transcript, you brought the new issue of a lease before the trial court. And the court was very curious about that.
Yes, Your
There's
Honor.
no executed release in this record at all. And this agreement in and of itself is very sparse, very bare. Doesn't even talk about cultivating trees, doesn't even talk about continuing the business whatsoever. Doesn't say that the trees are his personal property. And no matter how close they were, Mr. Lelsey transferred this property unencumbered from any personal property encumbrance, lease, exception, nothing.
Your Honor, there's not a single case, and after exhaustive research, I'm confident that there's not a single case in the country that says a person, when party A plants a tree on party B's land, if he doesn't have an enforceable written lease, then the tree transforms from personality into realty despite the contrary intent of the parties. And if you look at
Well, he couldn't plant these trees, also, he could not plant these trees without permission, Mr. Lelsey, correct?
he had permission.
Okay, well, you can't plant them without his permission,
Agreed, Your Honor.
okay? When he dies, the permission's gone, is it not?
Perhaps, Your Honor, but then you look at like the doctrine of implements and the cases that talk about at the expiration of a license or a lease, the personal property upon the real property doesn't magically transform from personality into realty so that the landlord reaps an unconscionable windfall. The courts talk about the doctrine of implements, giving at the expiration or termination of a license or a lease, the tenant then has a reasonable opportunity to remove the personal property from the real property. That's one of the exceptions to the ancient rule that's discussed in
And
a
did
number
that
of cases
happen?
we
Did
cite.
that happen in this case? Were any efforts done to do that at the time of Mr. Lisi's death?
There's no evidence one way or another, Your Honor. That would be for a jury to decide whether Mr. Kim acted reasonably under the circumstances or whether he acted promptly enough. And if you look, Your Honor, if you look at the case of King versus Wilkham, King and Wilkham had a partnership to grow and sell trees. The trees were planted on Mr. Wilkham's property, and then Mr. Wilkham lost that property in a foreclosure. And when that happened, the purchaser of the property at the foreclosure sale said, hey, those trees are in my real estate and that makes them my trees. And there's no indication that there was a written lease in that case. However, the New York Superior Court said because Wilkham gave King permission to grow trees on that land, the relation of landlord and tenant was created. And the same thing happened here. Now, do they have an enforceable written lease? That Mr. Kim could have sued Mr. Lisey for breach of lease? No, but he still had permission, and there's nothing in the case law that says personal property transforms to real property absent the presence of an enforceable written lease. The law just doesn't allow that kind of an injustice for someone to lose a 14-year investment and hundreds of thousands.
So it seems like that your entire case is built on this oral agreement, right?
Yes,
Okay.
it is.
And
It
Judge
is.
Smith asked you a good question about when two parties enter into an oral agreement and one of them dies.
Okay,
Are the heir successors and assigns bound by an oral agreement with which they were not involved? They have no evidence of, they have no way to verify or not. And the very person who the other party is, anything that person said or expressed is inadmissible hearsay. So
Your Honor,
what happens to your oral agreement?
the oral agreement survived because Mr. Kim gave Mr. Lisey 6,000 trees to grow his 4,000 on the other property indefinitely until he was ready to sell them. And the undisputed evidence is that the appellees knew about this agreement. In fact, Courtney Galasso testified in deposition. I don't have a record cite to her deposition testimony on this. Didn't know it was going to come up. But she testified, she knew that those were Mr. Kim's trees. She knew, her dad told her. So it's not like we're talking about innocent bystanders here.
Well, she knew her dad told her. Again, that's inadmissible hearsay. Right? So I'm just trying
It's an admission on her
I'm
part.
trying to work with your oral agreement because You know, it's a challenging concept. And because this is personalty, as you argue, and not realty, an oral agreement works, right?
Yes,
Okay. And under the UCC, an oral agreement works in this situation. Is that correct?
that's correct, Charlie.
Okay. How about the argument that it can't be performed in 1 year, which is a requirement of an oral agreement?
Okay.
I mean, this is a long-term project, right?
That gets us to what I referred to myself as the Summerlin gap. When you look at the case of Summerlin versus
And
Orange
just so
Shores.
you know, you're at 15 minutes, but use your time however you want.
Thank you, Your Honor. When you look at Summerlin versus Orange Shores, as well as the Stotesfullis case, both of those cases talk about the doctrines of fructus naturalis versus fructus industrialis, where the former is real property, trees that are naturally occurring. When acorn falls off an oak tree and germinates, it becomes an oak tree. That's part of the real estate. However, in fructus industrialis, the court talked about trees and plants that are the product of human cultivation, and it used the reference to annually harvested, because usually you're talking about crops. You're talking about something that is annually harvested, either fruits growing on trees or watermelons on the ground or what have you. But it leaves a gap. What about product of human cultivation that lasts longer than 1 year? Well, as far as I can tell, there are only 2 cases in the country that look at that question. One is Story versus Christian, and that's where the California Supreme Court said that a determination of whether nursery stock is real or personal, it turns upon the intention of the parties, and it goes on to say that it's common knowledge that nursery stock trees take years to mature, but that didn't change anything. Those trees were still considered personal property. Have Rainier National Bank versus Security State Bank, and that was the case where the gentleman had a 10-year lease to grow Christmas trees, and the opposing party in that case said, no, you can't treat those as personal property because they take longer than 1 year to grow. But the court rejected that argument and said the fact that Christmas trees take longer than a year to grow doesn't change their character as personal property when they're planted for the sole purpose of later being transplanted and sold to third parties, which is the same case as here. Unfortunately, no Florida case directly addresses that issue, but common sense dictates that nursery stock trees should be treated differently than an annual crop of oranges or an annual crop of tomatoes, for example. And Your Honor, I don't know how much
You're
time I
at
have
18
left.
minutes, so I want to.
I'll reserve the last 2
Okay.
if it pleases the court.
That's fine. You'll have 2 when you come back.
Thank you, Your
Okay.
Honor.
Morning, Your Honors. May it please the court, Dean Morandi of Carlton Fields, here on behalf of AGP Ruskin. Mr. Pittman is here, and Mr. Counsel for Mr. Galasso. Ms. Galasso is here as well.
Can I just ask you a question right out of the box? And I'm sorry to do it, but it's fresh on my mind because of what your opposing counsel just argued. We're here on an appeal from a summary judgment, correct?
Correct.
His argument is we had an oral agreement for personal property. That appears to be a disputed issue of material fact. Shouldn't we send it back just on that basis alone to give them a chance to prove their oral agreement?
No, because the statute of frauds precludes any such agreement. That's the law in Florida.
Okay.
You have to agree, and you have to ignore the Jenkins case going back all the way to 1882, saying that when a tree is in the ground, it is part of the realty. And there's just a nice quote from the Jenkins case. The doctrine is that though the simple agreement for the sale of trees is void as a contract for interest in land, standing trees being of realty. That's the end of the story. It should be the end of the story, right? Yet I think you hit it on the head. You have an agreement here, whatever it purports to do, it doesn't qualify, it doesn't satisfy the statute of frauds, and it's ineffective as a transfer of real property, which are the trees. It's ineffective as a lease, which could have something to do with the trees. Now, you heard some of these arguments like emblements. Those are situations that apply when there's a lease. In this case, there's no lease. My opposing counsel agreed that there's no lease.
Well, that's right. He's not arguing a lease. He's not arguing a license. He's arguing an oral agreement regarding personality. That's what he's arguing.
Well, I'm not quite sure how we got there to an oral agreement regarding personality, because it's changed quite a bit. It's evolving, obviously, but I'm not quite sure what is that not a license? Like, I think what I would understand that agreement to mean would be it's a license, which, as the court knows, is revoked upon the death of the grantor.
Well, licenses relate generally to realty, a license to use the realty.
Right, license in this case to come onto the land.
He's not making that argument. He's making the argument, we had an oral agreement regarding personality. Widgets, chattels, things. He's moved away from the real estate argument at all. We had an agreement, an oral agreement for stuff.
Right, and the only way you can do that is under the law of this state, going back over a century, you're talking about real property. You can't just ignore it. You can't just say, I'm going to ignore all this law saying that a tree in the ground is realty because I had an oral agreement to the contrary and I get to avoid the statute of frauds that way. You'd never have a statute
See,
of
one of
frauds
these
problem
old,
if you could do
one of the
that.
problems I have with these old cases is they predate the nursery industry. Okay, we just recently started growing trees to plant in subdivisions in our history.
I have a couple of comments to that, actually. Look at the Summerlin case itself, and this is actually the thing that they quote for. And they're talking about nurseries here. This is page 510 of the Summerlin decision. One claiming that trees and shrubs, and actually the preceding sentence talks about nurseries, whether growing naturally or planted and cultivated for any purpose are not part of, if you're claiming that it's not part of the realty, you must show special circumstances. And then it says, you must show that the parties intended that they be regarded as personal chattels. Now, in that, you're talking about, nobody's arguing, well, I say that, I'll leave that for opposing counsel to say, but it's my understanding that nobody's arguing that trees growing naturally can be personal property. You see here from Summerlin is grouping all of that together. They're basically saying it doesn't matter whether they're natural or whether they're in a nursery. They're part of the realty. And all you have to do is to get around that is satisfy the statute of frauds and a
Well,
transfer. or
Someone
have a
also
proper
says in
lease.
order to show that growing trees are not part of the realty, a party must show special circumstances which take the particular case out of the general rule, which the parties intended the trees to be chattels. And he's made that case. He's made that argument.
He hasn't, well, Summerlin doesn't just sub silentio overrule Jenkins and all the law stating that trees you have to satisfy the statute of frauds. By saying special circumstances here, they don't specify what they're talking about, probably because this case had nothing to do with that.
Well,
Summerlin had to do with what it takes to have a chattel mortgage and the priority between a real property mortgage and a chattel mortgage. They made this comment. What it does show is that there's not a distinction between nursery trees and trees growing naturally.
well, yeah, the problem I also have is Summerlin was in 1929. The nursery industry has changed a lot since 1929. Okay, as we all know, there's nurseries all over Florida now doing all sorts of things with somebody owning the property, somebody growing the trees, or partnerships. There's all kinds of agreements. So this one, frankly, is difficult because this was an agreement between two friends. It was oral. What little writing there is not helpful. And frankly, it's been misconstrued by both the parties, quite honestly, in your briefs. So this is an unusual case, and maybe a case that's ripe for a whole new world when it comes to the law of how this is.
I mean, it's possible, but I mean, one thing I want to point the court to, we're talking about, like, let's look at the Richboard case. That's a 1907 case. Yes, we're talking about forever ago. The industry is changing, but we don't have any cases talking about this because it's settled law. All these new agreements that we're talking about, they satisfy the statute of frauds. It's not a great burden to place on the parties, and it allows for certainty. And that's why I like the Richburg case for this quote. It talks about sales of growing timber are as likely to become the subject of fraud and perjury as are other integral parts of the land. These trees were in the ground for 15 years. This agreement that we're looking at is over a decade old. The other person who's the party to that agreement is dead.
See, the corollary of your argument, though, is that Mr. Kim gave these trees to Mr. Livesey because he's just a nice man.
Right, well, there's two sides to the argument, but the point is, that's why we have the statute of frauds. Somebody's not gonna be happy, right? Either the person who bought the property 3 transfers later has somebody coming in saying that they have an oral agreement. They don't even need a piece of paper. They can just come in and say, wait, I had an oral agreement with the person who transferred that property to you years ago, who's now dead, and you're not gonna be able to have any evidence to the contrary, but all I have to do is give my word, and I can take you to court, and I can get an injunction saying I can go on your land and I can tend to these trees for as long as I want.
But a sophisticated buyer would see this property and go, this is obviously nursery trees growing here. And I can't imagine this is going to be conferred as a gift to me when I buy this property.
What if
$1
it's-
million worth of trees.
What if it's one tree? Why would the rule be different for one tree?
We don't have those facts here. We
What-
have
what if-
$1 million
what if
worth of
I'm-
6,000 trees.
That's true, but why would the rule be different for 6,000 trees or one tree? If there was an oral agreement to plant one tree, say I have my one oak tree that I want to plant on your property, and you tell me, sure, go ahead and do it. I can come back 40, 50 years, what's the difference in the rule? You have to qualify, what qualifies as a nursery? Do you need 10 trees? Do you need 6,000 trees? That's why we have the statute of frauds. We have certainty as a result of the statute of frauds. You're talking about realty in this case. It has to be realty. Otherwise, you're going to have situations like this very case. When you're talking about 15 years later, we don't know what the agreement was. And the only thing we're going to know about the agreement is from Mr. Kim, because Mr. Livesey has passed away. That's the exact reason why we have a case law. And the reason why we don't have more recent cases on this, of course, I don't know this to be true, I'm only speculating here, but it's because people satisfy the statute of frauds. It's known in the industry. Right? And that's because that provides certainty in situations like this. And that's why we can say, under these facts, the trees were realty. They had no document that satisfied the statute of frauds. They had no lease that satisfied the statute of frauds. The cases that they cite to this course that are most on point, the Story decision and the other decision, emblements is another doctrine they cited. It all has to do with when there's a lease. And again, they're trying to get around that by saying, well, we had something that looked like a lease. No, there is a statute of frauds. You don't come in and say, well, it looks like it, so I get to treat it as that. That's not the law as it stands here.
You're at 9, almost 10 minutes.
Okay, perfect. I just wanted to save 2 for the cross appeal. And again, the situation is even worse here. Worse. The evidentiary burdens are even more stark here, because now they're saying that this 2011 agreement doesn't even matter. They don't need anything at all. They could have knocked on the door and said, I have an injunction. I have a right to get on your land and tend to these trees indefinitely and pull them out based solely on an oral agreement that I am the only one that knows anything about. So that's why the statute of frauds is here. That's why the law is that these trees are part of the real property under the statute of frauds. Unless the court has any questions, I'll just take a couple of minutes to talk about the cross appeal. I think that's pretty straightforward. That's why I think we only need a couple of minutes on that. That cross appeal has to do with AGP Ruskin's claim against Ms. Galasso based on the general warranty deed. We had a cross claim for indemnification and advancements of fees, and that's directly from the general warranty deed. The trial court
It wasn't even teed up, right?
exactly right. It wasn't part of the motions. It wasn't part of the hearing. There was no evidence presented on it. The trial court just sua sponte said, the claim is moot. I'm entering summary judgment. And we know that that's improper. I mean, we have just cases, dead on point talking about that. Their response is to cite more general due process cases, but you don't need general cases because you have cases directly on point. When a party has not filed summary judgment and when there's no notice, trial court may not sua sponte enter summary judgment. That's exactly what we have here. We don't feel like we need to get into the merits of the claim, but we threw some in there in the briefing just so you understand that it's not moot anyway, to the extent you wanted to look at the merits, which I don't think would be proper. You can't jump due process and say it's okay because the merits support that it's moot. But in this case, it's not moot. There is a duty to defend, and all the cases that you've seen from Ms. Galasso have to do with indemnification. And there's a duty to defend that kicks in the moment that there's a claim. And we have that briefing there. And unless the court has any further questions, I'll go ahead and turn it over to Mr. Lyman.
Thank you. Mr. Lyman, you have 7 minutes.
Thank you, Your Honor. Good morning. May it please the court. Chance Lyman on behalf of appellee, cross appellee Courtney Galasso. I know my time is short. I'll be brief, but please direct me if you have any questions. I'll just touch on the cross appeal first, since we just talked about it. None of the cases that were cited in the initial brief discuss a mootness ruling, a sua sponte mootness ruling. This court dismisses cases for mootness sua sponte all the time. It goes to subject matter jurisdiction. It's an issue that can be raised and resolved sua sponte. There's other reasons that it wasn't a due process violation. The case law is clear that you actually have to demonstrate that you had a property interest to show a due process violation. There is no property interest in a moot claim. And then there's also this issue with the rehearing. That is due process. They filed rehearing. They argued the claim on the merits at rehearing. They didn't use the phrase due process. I know they said that the issue wasn't noticed, but they argued the merits. The trial court rejected the merits, and they haven't shown an abuse of discretion in that ruling. I also think it's invited error for 2 reasons. One, the summary judgment asked for a determination that there was no lawful claim to title to the land. That's a determination that the warranty never applied at all. It sort of is connected to the merits. They don't address the Buckeye case. The 4th DCA Buckeye case, it is a duty to defend case. It's not an indemnification case. And it says it's not triggered when there's no valid claim under the warranty to title to the land. That's what the warranty says. If you look at the plain language of the warranty, you'll find that. We provided supplemental authority, the Larson case, it just continues that same principle. I think it cited the Bullware case. Also, the indemnification portion, which is distinct from the advancements, that was pled as contingent. So that is essentially another version of the invited error argument. And I also just want to note that the attorney fee motion should be denied because that seeks fees for fees on the cross appeal. That's not defense fees on the main claim. Turning to this, the resolution of the main appeal, I want to take a different approach. I see this as a preservation problem. The only argument that was raised in opposition to the summary judgment was a lease. That was not pled. They said paragraph 12 talks about a lease. It doesn't. I know the court will read the record itself. Paragraph 12 doesn't talk about a lease. And I also want to direct your honors to I'm sorry, I don't have the record page, but it's page 3.
Except for Mr. Lyman, you heard that his argument this morning is not about a lease. It's about an oral agreement.
Absolutely,
Your Honor, personal.
I did hear that, but that's too little too late. That's why this is a preservation matter. I don't think it's proper to tell the trial court one theory, exclusively one theory, and then tell this court that the trial court erred based on a different theory. I don't think that's proper. We certainly objected in the trial court that the lease theory was not only unpled, it wasn't supported by a written lease. That's still a problem. I understand that today we're talking about an oral agreement.
But it seems like in the trial court, that's what they were arguing, is that they had an agreement.
I want to read for your honor their written opposition to summary judgment. Paragraph 5 is on page 3. The intent, and this is speaking about the 2007 initial set, whatever this oral agreement was. The intent of the agreement between the parties was that Mr. Kim would rent Mr. Licey's land. That's a lease. I actually highlight there's 8 or 9 times where they talk about a lease.
Yeah, it started out with that $3,000 annual rent, and then that sort of went away because Mr. Kim was using his equipment and doing all the work.
I think that's actually later in the timeline. That's at 2011.
Okay.
And that's why I think it's important. 2011. There have been arguments made throughout this litigation that 2011 was the origin of the lease. I just really think this is as simple as looking at what was in opposition to the summary judgment below. I think we need to keep the moving target settled. I think Judge Sleeve is correct. This has been a moving target.
Well, let me ask you this question. Let's assume it's an oral agreement for personal, but is it really just that? Because Mr. Leslie had to do something. He had to keep his land maintained in order for the trees to grow. And the nature of the personalty is going to take more than a year. So is there a service on the part of Mr. Leslie by virtue of this oral agreement?
As I understand the
And there's a
facts,
service, there's a equal service by Mr. Kim to keep it clean.
as I understand the facts, there was only the provision of the
So
land.
okay, so if Mr. Kim, by virtue of this agreement, is not responsible for maintaining the trees, because that's not what it says, Mr. Leslie is. So the statute of frauds apply.
I absolutely think the statute of frauds applies. I think the fulcrum to this is that the trees can't exist without the land. That's why they need the lease, and that's why, you know, Judge Lee, you identified this earlier, they need permission. You gotta get permission. Their theory is that Lycee gave them the land so that they could grow the trees. This whole idea that there was a transformation is a bit of a red herring in my mind. They say Lycee gave them the land. That's what they said below. I think that's the argument they're stuck with. You can only give somebody the land in this state by complying with the statute of frauds. They have conceded in their brief, I think appropriately, that there's no written lease. They're never going to be able to do that, which, Your Honor, Chief Judge Morris, that's why this is not the test case for what could be an interesting question. This is not the test case because it fails for preservation, and it fails for the written lease. This oral agreement that may or may not exist. I mean, as I stand here now, I still don't know really what it is. I don't think anybody does. This is a case where they made their argument in opposition to summary judgment, and that's the argument that they need to continue here, and it fails for lack of a written lease. You know, Chief Judge Morris, the idea that the nursery industry maybe changes this. We cited the Fisk case. That involved palm trees and a nursery. That was the scenario. And the court there held that those trees were real property. Certainly different facts otherwise from what we have
These
here.
cases are all very fact intensive.
They are. And in that sense, I wanted to, you know, highlight the Mid-Florida grower case. I like that case. It's from this court. And this court made a really important distinction, at least, you know, academically. Containerized nursery plants, we'd be talking about a whole different situation there. But
You're down to 10 minutes left. I mean,
Oh,
10 seconds.
well, if there, I just
You're
wanted
feeling
to,
good.
I like the Mid-Florida grower case. I think this court hit the nail on the head that if you had planted those nursery trees and they stay there for over a year, I think that's critical. In fact, these were a decade, then that's real property. If there are no other questions, I'll rest on the briefs.
Thank you. Yes, sir. You have 2 minutes.
Thank you, Your Honor. Yes, my opponents say repeatedly, we're talking about realty, we're talking about realty. Well, they were not, those trees were not realty when Mr. Kim went to his mature Sylvester palms and harvested the seeds, or germinated them out on mats, or spent the next 4 years nurturing them, growing from larger and larger pots until they were in 15-gallon pots.
No question. They're personal to you then. But
Personal
the
to-
question is what happens when they're put in the ground?
And the answer is, Your Honor, that the appellees at the summary judgment stage had the absolute burden of proving irrefutably that the moment those trees touched the ground, they transformed from Mr. Kim's personality to Mr. Lysee's realty, despite both parties' contrary intent. There's no authority anywhere to support that proposition. There was an argument regarding the Richboard case that says that trees, they quoted some language, I may not have to quote exact, but it's something like, trees are just as likely to be the subject of fraud as other property. That's true, especially if this court adopts the trial court's conclusion and decides that trees transform from personally to realty against the intent of the parties, because in that circumstance, Mr. Lysee could have said, hey, Mr. Kim, you know, we've been friends a long time, and you got all those trees over there, and I've got this land over here. Why don't you plant 10,000 of your trees worth a couple of $1 million or more on my 2 parcels of real estate? We'll grow them up together. We'll share the expense. and then we'll sell them and split the profit. And then Mr. Kim sends out dozens of people to plant 10,000 trees on 2 properties. And then Mr. Lisey could just say, gotcha, your trees just became my real estate. Get off my land before I call the police. Now, does the law allow that kind of
Well,
injustice?
as I said to you in the early going, it's too bad he didn't have a lawyer at the front.
Your Honor, the law protects the citizens against an injustice like that, regardless of whether they have a lawyer. And there
It
is,
doesn't protect 2 people who freely and voluntarily make a bad agreement.
I don't think it was a bad agreement, Your Honor.
And you're out of time, sir. I'm sorry. I'm very sorry to do that.
Your Honor. Apologies if I went over.
Let me say this, though. You all did an excellent job with this case. The briefing was good. Your arguments were excellent. And it's a unique case, and I appreciate the effort. It helped us a lot.
Thank you.